Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, do we need a check? Big Tech and the American Innovation and Choice Online Act. There have been many calls to rein in big tech by Democrats and Republicans alike. In this episode, we will speak to a proponent of one such measure, the American Innovation and Choice Online Act. Joining me today is my co-host, Melissa Maxman. Welcome, Melissa.
Hi, Christina.
So what are we talking about today?
Well, big tech is in the news, obviously, and there are federal and state lawsuits, many of them against the big four, aka Google, Apple, Facebook, and Amazon, or GAFA, plus Microsoft and TikTok, some talk about. And the U.S. Congress is considering legislation to rein in perceived discriminatory practices by these mega firms. Today, we're going to discuss one of these bills, the American Innovation and Choice Online Act, which is S 2992. It's co-sponsored by Senators Klobuchar and Grassley and was voted out of the Senate Judiciary Committee by a bipartisan 16-6 margin in late January. It's intended to limit the power of the tech giants by preventing them from self-preferencing their own products over those of their rivals. Its proponents claim that comprehensive antitrust legislation is needed to restore competition and ensure small business owners have an opportunity to succeed. However, detractors warn of unintended consequences resulting in harm to consumers.
Great. And we do have a second episode dropping today of an individual who is, a detractor of such legislation. Today, we have a proponent. Melissa, can you tell us who our guest is today?
Sure. We are very honored to have Luther Lowe. He's the Senior Vice President of Public Policy at Yelp. He joined Yelp in 2008 as an account executive on the company's sales team, and a year later moved into the role of Manager of Business Outreach, where he built a department that educates small business owners about the importance of Yelp. Since 2011, Luther has led public policy at Yelp. As Senior Vice President of Public Policy, he manages and directs the company's global outreach to policymakers about the vital role Yelp plays in driving economic activity to local businesses while serving as a platform to empower and protect consumers. Previously, Luther worked as a special assistant to retired four-star General Wesley Clark. He holds a BA in government from the College of William and Mary. Welcome. We're really glad you're here. Can you start by describing the problem? What does S 2992 actually do?
Senate Bill 2992 is designed to curb the most egregious forms of self-dealing by the most powerful gatekeeper companies, notably Google, Apple, Facebook, Amazon. But of course, it would affect, Microsoft and a couple others as well.
And in particular, we've been hearing about this self-preferencing. What exactly does the bill do? How does it do it to keep these monoliths from self-preferencing?
Well, the bill defines it has mechanisms in place to basically define whether a particular company sort of would qualify in terms of being in a position to self-preference in such a way that would distort the market. So there are specific provisions in place. For example, you've got to be over 600 billion in market cap, and that's got to be true over kind of a lengthy period. And essentially what the bill is trying to get at is that these companies have market power. And then it essentially makes it creates mechanisms and lowers the bar for the government to win a case. So there's no private right of action in the bill. It really is just about creating stronger tools for law enforcement, state attorneys general, DOJ, FTC, in curbing the most egregious abuses by these dominant platforms.
So, as you're at Yelp, how does Google self-preferencing hurt Yelp?
I would just take a step back and say there's examples of egregious self-preferencing by all the major dominant tech platforms. Whenever I'm using Facebook, for example, and I want to just share an image, or let's actually say it like this: when I want to share an image on Instagram, this morning when I shared a picture of my wife and I saying "Happy Valentine's Day, honey" on Instagram, I'm getting hit with sort of interstitial saying, "Why don't you share this to Facebook?" And I say, "I don't want to put that on Facebook. I don't really use Facebook anymore." And so it's these pernicious little nudges that we get anytime we're using these services. Like if I'm, in my Apple settings and I'm getting nudged to subscribe to Apple Fitness or Apple Music. If I'm, on Amazon and I'm getting, seeing preferential treatment for their, copycat products that they've sort of ripped off from third-party sellers after, studying their underlying data, and then in the case of Google, if you're a mom looking for a pediatrician in Arlington, Virginia, i.e. conducting a local search today, instead of matching consumers with the best information from across the web, which was Google's original value proposition, they hardwire objectively lower quality information from their own business reviews to their Google map. So, contrary to what some of the front groups that represent big tech in this debate have said, the 2992 doesn't get rid of the Google map. It just says you can't egregiously self-deal. You can't you can't tether that map to inferior content. There is a sort of a right of defense and mechanisms in place that allow for certain types of integration. But if there's no real efficiency justification for that type of integration, then that type of conduct, I would say, would be more easily targeted by enforcers if this bill passes.
Well, so what about critics who claim that this bill is going to hurt consumers in order to help now smaller tech companies get bigger, like Yelp? Is it really going to be they claim that it's going to be turning back the consumer welfare standard in antitrust that's guided antitrust policy for 40 plus years. They're saying this doesn't really help consumers get cheaper or better goods. It's just helping the smaller tech companies that offer additional services or dedicated services like Yelp.
Yeah, I mean, it seems like every point being made by groups like Chamber of Progress or CCIA or NetChoice or any of these, groups that are totally funded by Google, Apple, Facebook, Amazon, and seem to kind of create sort of a Truman Show of shills in Washington these days. Every point that's being made by them is like so Orwellian that you can almost, like, if you want to sort of glean the truth, you just invert it, and it's really the opposite. It's, traditionally more competition means better products for consumers. And so the absence of competition means less innovation, less benefits for consumers. But, if you're, and consumer welfare standard has been used to sort of move the goalposts in terms of enforcement. So I think I would kind of decouple two things. Like, the first point is that no, it does not hurt consumers. It actually compels these firms to behave in a more interoperable way, which actually improves consumers, it increases consumer benefit. So, in the example of the mom looking for the pediatrician I used earlier, instead of being matched with a corpus of objectively lower quality information that's more bogged down with spam, and there's been independent studies showing that Google reviews, for example, are more likely to have fake 5-star reviews. Instead of being sort of siphoned into that experience by Google, they would be met with an interoperable map powered by third-party services like ZocDoc, RateMDs, Health Grades, services that specialize in the cultivation of aggregating user-generated content from fellow consumers about who are the good doctors and which ones do you want to steer clear of. And so that type of interoperability, I would argue, is a consumer benefit. The same with the Instagram example I used earlier. If I'm why do I not have the ability to push that whatever I'm sharing to Twitter or to Snapchat? These firms intentionally make their systems closed as a way to protect and maintain their dominance. And so I think that Senate Bill 2992 would compel these firms to behave in a more interoperable way.
Luther, you've mentioned a couple of times objectively inferior products, data, reviews. How do we determine what is objectively better or worse when it comes to some of these products and services? And, does 2992 take that on?
Well, I would say that the first question is, you don't have to take my word for it. The Federal Trade Commission released a study last year by one of their in-house economists that essentially scraped lots of third-party review services and looked at things like what are the average character counts, what is the rating distribution, the type of signals that would indicate whether that type of ecosystem is bogged down with spam versus is it more trustworthy? And they found that Google, compared to the third-party services, was more likely to have systematic rate inflation. And I think that type of, those types of patterns you also see on a service like Amazon. If you go, I bought a kite for my daughter a couple months ago on Amazon, and it had like thousands of 5-star reviews, and it came and it arrived and it was terrible quality. I couldn't assemble it. I had to return it. I wrote a 1-star review about the product, and then within a week, I had this email saying, "Hey, if you change your review to 5 stars or delete it, we'll give you a $20 gift certificate." And I think so. There's like this interconnectivity between. I think that there's like this real consumer protection problem where you have online review sites that are getting that are allowing this sort of rampant misinformation, and a monopoly problem where you basically have companies that don't have any kind of mechanism or discipline within any kind of market force disciplining them. So if Google tells me that a lousy restaurant is a 4.5-star place, like if Bull Feathers is, I think, like a 4.2, 4.3, this lousy bar on Capitol Hill. And I, not knowing any better, make a dinner reservation there with my family one night, and I have a 2.5, 3-star experience, which is what the Yelp rating for that same business is. Then even though Google has done a poor job at predicting my offline experience, I'm unlikely to go into my iOS defaults and change it to DuckDuckGo or Bing, because these firms know they have that's why they spend $15 billion. That's why Google spends $15 billion a year on those defaults, because it increases the cognitive costs of switching. And so I think that there's a lot of evidence that shows and a lot of third-party independent evidence showing that these services that and the online reviews on these big platforms are just less trustworthy and are essentially sort of a minefield of misinformation. And so that's just one example of a negative externality that these types of that the dominance of these firms produces. And so that's why I think this bill is really exciting, because I think it would compel these companies to interoperate with third-party services that don't have the luxury of having spam and misinformation sort of pollute their services. And so I think it's got a lot of promise.
So it sounds to me like you're defining consumer welfare as better quality, more choice, as well as lower prices. But what about, and that's a good argument, but what about making things more cumbersome for consumers? I mean, polls show that consumers want to control the tech giants, but they don't, not if it makes their online experience and purchasing options less convenient. So is it true that this bill would prevent Amazon from featuring its Amazon Basics house brand and prevent it from offering Amazon Prime experience to current users enjoying it?
No, that's not true. And in fact, the head lobbyist for Amazon, when he was pressed on that in a Politico piece a few weeks ago, conceded that that this bill is not going to make Amazon Prime go away, just like the bill is not going to make Google Maps go away. I think again, it compels interoperability, and that means that you're not talking about sort of interruptions between service A and service B. It is a connectivity and sort of seamlessness. And there's no technical reason that that the large firms can't design their services in a way that sort of plays nicer in the sandbox. The very reason they're doing that, and why this legislation is so important, is because they use these tactics of self-preferencing as a way to protect their dominance, because they're less innovative. They're not coming up with the best ideas anymore. They're basically just sitting on billions of dollars in cash, and they're no longer innovative companies. And so they have to monitor the horizon and look for nascent startups that they can either purchase or kill or clone and integrate their features. All of the above in some instances. And so the consumer welfare standard has been used as a way to sort of deflect scrutiny, to say, oh, well, this doesn't pass the consumer welfare standard. Well, we know even conservatives like Senator Mike Lee have very recently reminded folks that consumer welfare standard doesn't always have to be a price increase. You can show a quality loss, and I think there's some interesting arguments, for example, being made in the Texas ad tech litigation against Google around sort of loss of privacy that consumers experience. So I'm not saying that I'm not really, I guess, making a position or putting forward a position on whether the consumer welfare standard is adequate to or for enough to deal with these issues. I do know, just anecdotally or personally speaking, having watched for over a decade a consumer welfare standard being used by people on Google's payroll and big tech's payroll to claim that that everything is fine. Seems like it seems like that concept has sort of been co-opted and hijacked and used as a way to kind of create an excuse to not enforce the law.
Well, I've heard some people who are from the giant tech companies, Google, Amazon, Apple, Facebook, saying that this isn't really that the Yelps of the world are not really trying to protect consumers. They're really trying to protect their own supply. Now, the GAFA would call Yelp a supplier. You would call Yelp, I guess, a competitor to big tech, but or TripAdvisor or Spotify. All these companies that are more focused. Do these suppliers, or do you feel that you'll be sacrificing consumer experience by giving them too many choices?
No, again, I think that is more sort of myths by big tech. I mean, this bill helps consumers by promoting competition and interoperability. And so if you have a more competitive landscape, does it hopefully get us closer to or put us back in the direction of a pluralistic competitive web the way that the internet operated 10, 15 years ago? Again, I hope that that's the case. And if you have a more pluralistic and competitive environment where it is dynamic and people are using lots of services instead of just staying inside one of two ecosystems, then that's a good thing. And so, yeah, if a company, 1/1000th the size of Apple's market cap, Yelp in this case, grows a little bit in that environment, great. But it also encourages competition from, Yelp-like services that have never existed before, who in that dynamic environment can create a new spin on these things. And really, honestly, there should be hundreds of Yelp-like services. Local search is the most common thing people do on Google. There's literally billions of local searches in the United States every month. And so there's a massive market where to sort of compete over. And unfortunately, that's been highly distorted because Google hardwires its own inferior house product to the top of the search results, irrespective of merit. And on a smartphone device where most local searches are happening, 80% of the clicks are going into that walled garden. 15 years ago, in 2004, or over 15 years ago now, I guess 16 years ago, the 17 years ago, 18. Gosh, we're now 18 years from the
old.
math is hard. The Google IPO in 2004. There was a transcript of an interview between Google co-founder and former CEO Larry Page, and he's being asked about, what do you think about search engines of the current day, like Lycos and Ask Jeeves and MSN, and he says, those companies are portals or walled gardens, and I'm sort of paraphrasing here. And at Google, we take the opposite approach. And now it's a direct quote. We want to get you on Google and out into the web as quickly as possible. In fact, that's the whole point. And so he described this sort of turnstile model. And so if you think about 2004, virtually 100% of Google's traffic was being diffused out into the web. And it's hard to decouple the rise of Web 2.0 from the rise of Google itself, because it was this engine that really grew Web 2.0. And today, if you look at third-party independent analysts who study this stuff, it's like 2 out of 3 visits to Google terminate on Google or go to Google secondary pages. And a big part of that siphonage is in local search. So back to your question, yes, of course, this, if you take 2/3 of all the billions of queries that are flowing through Google every week in the United States and diffuse them a bit on the web, of course, there's going to be services that grow a little bit. But the benefits for consumers and competition that unlocks should be obvious.
Our audience is mostly antitrust lawyers. And from a legal perspective, purely legal, I don't think there's been another antitrust bill that has ever passed that singles out a particular size of platform. Isn't it fundamentally unfair to say, well, because you're big, we're going to put additional restrictions on you?
I think that, so no company is singled out in this bill. I mean, I think that there have been some unpersuasive critiques related to the market cap threshold. And I think that many of the people who make these arguments, I notice, work for libertarian think tanks who are funded by big tech. And I think that these folks have to make a decision. Do you believe in the efficient market hypothesis, or do you believe that market caps are an arbitrary, non-objective measure? I happen to think that market caps are a really great signal to understand how much market power a firm has. So, for example, there's a reason that Amazon has more investors and more money in its total market cap and trades at higher multiples than Walmart, because it has it has gatekeeper power. If you read any of the analyst reports, the Wall Street analyst reports, they talk about pricing power and they talk about Amazon's deep moats, and these are all interchangeable with monopoly. So I think the reason it's not singling out any firms, it's taking these firms that are on the very edges of the spectrum, who have market power, don't just have market power, but are abusing that market power, and gives the government better tools to rein in some of the most egregious abuses.
So, Luther, we opened the episode talking about a lot of the attention that big tech has been getting. And there's ongoing litigation against Google, Apple, and others that target some of the self-preferencing conduct that is also the subject of 2992. There's the Digital Markets Act, which is a sort of comparable legislation in Europe. Sort of in view of litigation and the prospect of international regulation of these entities, why do we need 2992 in view of if there is risk that it could overcorrect in light of litigation and other regulation that's sort of in the pipeline?
Well, I don't guess we don't know. I guess I would say that this strengthens an already strong hand that the DOJ and the FTC have. The reality is we have in these high tech markets, we have stopped enforcing antitrust law, and that has led to sort of a cultural paralysis in the enforcement agencies. I think we now know through all the leaked documents from the FTC's original investigation of Google, all the assumptions that people like John Yoon and the alumni of that case, that many of whom went through the revolving door to work for academic institutions funded by big tech or for the big tech firms themselves. All the assumptions based on the baked into those conclusions that they shouldn't bring charges have aged quite poorly. And so I think that it finally got to a point with Europe sort of leading the way, and Commissioner Vestager leading the way, that these companies have just gotten too powerful, and we need to enforce the law. And so I think if the laws are stronger, that's great. We're strong proponents of the DMA, and I think and I hope that passes, and I think that European consumers are going to be enjoying better protections than U.S. consumers if we don't pass 2992 and Europe passes the DMA. But that doesn't mean that we have to have 2992 in order for the FTC and DOJ to be successful. But I do think we need a more robust enforcement regime, and we need to be bringing cases like this a lot more often if the government hopes to prevail more frequently.
And I know we're reaching the end of our time, but I want to change tracks. One last question. A number of detractors have looked at the provision that S992 includes, that covered platforms are not permitted to discriminate against similarly situated businesses. And they argue that this would prevent the platforms from blocking sites engaging in content violations like hate speech and promoting violence. Is this really a problem?
No, Yelp is a major consumer internet company, and as such, we get sued for silly reasons. A lot. We've gotten sued for over the years, lots of silly things, if there were any question about whether this was going to be an issue, I think it was clarified in the manager's version of the bill, and we are not in any way concerned. And we're often alongside groups like Free Press, who I know have raised concerns about this, arguing on these issues, whether it's about CDA 230 or any kind of hypothetical exposure that could be unleashed, unintended consequence. And this critique is more FUD by big tech, designed to drive a wedge, and it is not it's not real. It's a hypothetical academic fantasy. Like these types of cases would not prevail, and so we're not concerned by the particular provision you're referencing.
So Melissa described that as the last question. It was the last substantive question, but we do have a few more for you. The first is to tell us something interesting about yourself that those you work with wouldn't know.
Those that I work with would not know?
Correct.
I'm from Arkansas. I have my wife is a journalist in that covers sort of the DC political world. So we don't overlap, but I have somebody that at the end of the day we have interesting conversations and are able to kind of I think we'd probably drive each other crazy if I were also a reporter or she were in tech policy. But I think and we have an amazing 3-year-old daughter, and and I'm from Arkansas. That's all I've got. That's I knew
three very interesting facts. The Arkansas. I love it. And do you have advice? I know you're not a lawyer yourself, Luther, but for folks who sort of want to get into public policy, who want to get into big tech, who want to have an impact in DC, do you have advice for those young professionals looking to do what you do?
I think one interesting thing to watch during President Biden's appointments of folks like Lena Khan and Jonathan Cantor is that you saw rumors and sort of reporting of like, oh, this person is going to definitely get it, or this person's going to definitely get it, and then you would see sort of subsequent reports about, oh, that person worked for Google at one point, or that person worked for Facebook at one point. And so, I think the takeaway for me from just observing all that is that, and the advice for young lawyers is that the norms have shifted. So I guess everybody is entitled to, what's the old adage, like everybody's entitled to an attorney, but that doesn't have to be you. And so, Google, Apple, Facebook, Amazon, working for these companies, I predict increasingly is going to be like a scarlet letter that will, haunt you throughout your career and become disqualifying. And I think that's what we saw in the most recent appointment process, is that it seemed like, again, I'm just sitting on the sidelines reading the tea leaves here, but it seemed like working for GAFA became sort of disqualifying. And I think anybody who is a young attorney who's looking at their career ahead and presumably into the antitrust field, if they're listening to this podcast, should take note of that.
Is that a call for applications, Luther, for Yelp antitrust attorney?
We don't actually have any in-house antitrust counsel. We are a very lean, scrappy operation. It's just me, and then we have like one or two outside folks that help us on this.
Great. And now for our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
Luther, could you pick a number 1 through 10?
2.
2. When you were a kid, what did you want to be when you grew up?
As a kid, what did I want to be? I think I wanted to be
a kid in Arkansas.
Yeah, I think I wanted to be some type of political leader. So, and I think that if I could go back, I think I just love my job. So I've always been sort of a computer nerd, and I've also been a really big political dork. And so I think if I knew my job existed, and I guess whenever I was a little kid, jobs like this didn't really exist, consumer internet company, public policy person. And so, if I could get into a time machine, I would, and say, what do I want to be when I grow up? I would say exactly what I'm doing right now.
That's really neat. I can honestly say when I was a kid, the internet didn't exist.
Yeah.
Well, I'm happy to hear that you love your job as much as you do. And we do very much appreciate your time today. And to all those listening, thanks for listening in. And we hope you tune in next week for yet another episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.